This is a censure from the North Carolina Bar Association. And it's against Tamara Lee, the attorney, who has been committing fraudulent activity and barratry against Allen and giving his client advice to keep the children away from him for over a month and a half. But thankfully, he got his children back last weekend. I'm going to read over this with you because this, along with what happened with Greg Newman, should be pretty self-evident about how the legal society works and how the state government works in North Carolina for protecting and upholding your rights, the people who allow it to exist. So I'm not going to read a lot of this stuff up top, a lot of this stuff that's kind of underlined. I'm just going to go over this with you. The State Bar staff investigated the complaint because they received a complaint. The discipline and disability rules of North Carolina give them the right to investigate it. The information available to them about the situation, including the response that Tamara wrote back after the letter of notice. The subcommittee found probable cause to investigate her, and this is absolutely hilarious because they write down here, they say probable cause is defined in the rules as reasonable cause to believe that a member of the North Carolina State Bar is guilty of misconduct justifying disciplinary action. No, probable cause does not mean reasonable cause. And you want to know how I know this? Is because when they were writing all the constitutions, if they meant to say reasonable cause, they were all pretty smart, intelligent men. They would have said reasonable cause and not probable cause. They're two different things. But see, when they changed the rules to say reasonable cause, well, now they can just make up whatever they want to make up, and they can say, oh, it's reasonable. I reasonably thought that. And this is just how they change the rules and wordings to take away your rights. Now, it keeps on going on to say that the grievance committee, having the probable cause determine filing of the complaint and a hearing before a disciplinary hearing commission are not required. Okay, so even though a member of the public has brought a charge saying they did something illegal, they're not going to hold a court over it. They're just going to issue the censure. Now, let me get into it. Here's what it says. It says that Tamara Lee's associate erroneously agreed to enter into a consent order in 2 child support cases in which you represented the respondents. These have to do with consent orders again, the same thing Tamara Lee is complaining about with Allen. You indicated to one of the local DSS attorneys that you wanted the consent orders set aside, just like she was trying to set aside the contracts that Alan and Katie got into lawfully. She's trying to set aside the consent orders from the court where, obviously, with consent orders, all parties consented. He told you on 2 occasions that he was not handling child support cases, and you would have to address the matter with the DSS lawyer who was assigned to the child support court. You did not contact the assigned lawyer and did not serve her with either motions to set aside or proposed orders. Well, this sounds a lot like what she has done to Alan, because she won't communicate with Alan. She never served Alan the motion for contempt of court and the order to show cause, yet she filed with the court that she had served him through the sheriff's office, which they still can't produce whoever served Alan up to this point. Let's get back to this. Instead, you approached the judge ex parte with orders to set aside, in both cases, representing to the court that opposing counsel had consented to their entry. One of the orders to set aside contained a findings of fact stating that your client was disabled. Instead of having an actual hearing, she goes to a judge ex parte and tells the judicial officer that everybody consents. Everybody consents. A judicial officer should have never done that without everybody agreeing to the judicial officer, because that's firsthand knowledge of the facts. What Tamara Lee did was all hearsay, and the judicial officer acted outside of law by signing those documents. Think about that. And again, just like she misrepresented the facts of the client being disabled, it's just like how Greg Newman misrepresented the facts of contacting Valerie Owenby's family. And they call it misrepresentation of facts, but because they are attorneys and they swore an oath to practice law, I call it perjury. She knew she was lying, just like Greg Newman did. There was no evidence other than your client's bare assertion to support those findings. That kind of sounds a lot like what's happening to Alan. There's no evidence of anything that Alan did wrong except for Tamara and Katie's assertion that this is going on. They have absolutely no proof and no evidence. And the court just keeps letting them move along with this. And you have never raised the issue of your client's purported disability with opposing counsel. The judge entered the orders based on your representations, but later set them aside after receiving information that they had been entered without opposing counsel's knowledge or consent. That's really interesting because the judge investigated it and then set the stuff aside because of the investigation. But do you remember when I made the video talking about how the order and the motion could not have been filed with the clerk's office at the exact same time without some type of shenanigans going on? And what Emily Cohen just said is that doesn't matter anymore. We don't care about bearing false witness. We can just make stuff up and drag you into court and beat you up and take your property and waste your time. Make sure you can't go to work on time because we're Emily Cohen. Right here. Here's the order to show cause. And this is dated October 14, 2021 at 12:02 p.m. This is the order to show cause dated October 14, 2021 at 12:02 p.m. If you're used to watching my videos, you know that's going to be important. For the relief prayed for, see, they're praying to the court. They're praying to their gods. Can you believe that they wrote that in there? If he even has any cause to not go to jail for doing nothing. So here's the motion for contempt. October 14, 12:02 p.m. I can't sell man and woman's soul, so let me just go back for a minute. Procedure in law is for motion to be filed with court clerk and have proposed order attached. After filing with clerk, a judicial officer is to review motion and issue order if cause, if any, shall be found. Time proves beyond a shadow of a doubt that documents, motion for contempt, and show cause order could not possibly follow this process of law, as said documents are time-stamped by the clerk at the same day, on the same day, at the same moment. It appears Emily Cowan show favoritism to Tamara and prejudice to myself. How come no judicial officer has investigated that? Why don't they look into those things? Seems kind of interesting to me. And they set aside these orders in a civil case dealing with child custody, but they haven't set aside the plea bargain that James Sapp has made that everybody knows is illegal and unlawful. And they've even investigated it. They still don't set it aside. You want to know why? My personal belief is because James Sapp paid them for that plea bargain. They probably got tens of thousands of dollars, and they know that if they arrest him again, he's going to squeal like a stock pig. And that's just my opinion. It's not a fact. That's just what I come to the logic to by seeing the facts and the documents within the case. It's just my personal opinion.
Did Mr. Newman ever seek an audience with you after the October 2015 hearing to correct the false statements he made during the SAP plea hearing?
Not that I recall, no ma'am.
Did anyone from the district attorney's office seek an audience with you to correct the false statements about victim notification made during the SAP plea hearing?
Not that I know of.
Okay, so Athena testifies, the judge who was sitting on the bench and accepted the plea, that she would not have accepted that plea had she known that the victim's family hadn't been notified. Why is this, you might ask? Because she knows that it's against the law to accept that plea, just like Greg Newman knew it is against the law to offer that plea. Athena continues her testimony to state that Greg, nor anybody from his office, ever contacted her to correct the record. It's a joke. They even found that he has absolutely no remorse. He has absolutely no remorse. Listen to this.
We found subsection P, but would characterize that as an absence of remorse. And whether in the drafting of this order, if you want to acknowledge that, P, absence of remorse, or you can stick it under V, any other factors, and do absence of remorse there.
They're not going to do anything. So what are we going to do? By failing to provide the proposed orders to opposing counsel and by neglecting to notify opposing counsel of your intent to present the orders to the court, you failed to comply with the known local customs of courtesy and practice of the bar without giving opposing counsel timely notice of the intent to comply with rule violation, I don't know their codes. Further, by telling to the judge that opposing counsel had not seen the orders and was unaware of their content, including the findings of fact based solely on your client's untested assertion about his disability, you failed to inform the tribunal in an ex parte proceeding of all material facts known to you that would enable the tribunal to make an informed decision in violation of rule Basically, you lied, you misrepresented things to carry on fraud. And all they're going to do is issue a censure, which is basically like, don't do that again. And then it continues to go on talking about how she contends that the DSS lawyer that she did speak to gave her consent, but there's no evidence of that at all because she just keeps making stuff up. And they find her guilty of the violations of the rules and dishonesty and causing prejudice to the administration of justice. No real punishment. She ends up, and here's my favorite part right here. You are hereby censured by the North Carolina State Bar for your violation of the rules of professional conduct. The Grievance Committee trusts that you will ponder this censure, recognize the error that you have made, and that you will never again allow yourself to depart from the adherence to the high ethical standards of the legal profession. This censure should serve as a strong reminder and inducement for you to weigh carefully in the future your responsibility to the public, your clients, your fellow attorneys, and the court, to the end that you demean yourself as a respected member of the legal profession whose conduct may be relied upon without question. She won't communicate with Alan. She's doing atrocious things against Alan. She's telling her client to do atrocious things against Alan. She's still making stuff up against Alan. And this was sent to her and ordered on February 15th of 2021. And she's still practicing this way. This is why censures and the administration that the legal society produces for themselves, because we're all too stupid to understand what's going on. This is why that doesn't work. You want to know what would work? Is if Alan could go as a man and sue Tamara for the harm, injury, and loss she has caused him through her vexatious litigation, making things up, having stories made up. And again, a lot of this has to do with DSS. Alan has had anywhere from 4 to 8 DSS complaints made against him, to the point where DSS is like, this is ridiculous. This is how the system works. This is how the parent who shouldn't really be raising the children seems to always get them, is because they are unethical, they're scrupulous, and they just don't care. And when they get caught, they don't ever get punished. It just gets suggested to them that they should actually do their job. And they don't care because they fined her $350. They'll give you traffic tickets over $350. But she can violate the law, put in bogus orders, lie to the court, lie to the judicial officer, make up stuff when she's talking to the Bar Association that nothing can be collaborated upon, and they only charge her $350. How do you feel about that? And this is why the public has to start watching these people, because this is exactly what happened with Greg Newman. And let me go back to this for just a second. Right here it says, the grievance committee believes that a hearing before the disciplinary hearing commission is not required in this case and issues the censure to you. And you want to know why they don't wish to have a disciplinary hearing before a committee? Because they would actually have to open up a court, even if it's administrative, bring in witnesses to testify and investigate what's going on in here. They don't wish for the public, for you to know which judicial officer signed those orders. And I don't know who it is, but my guess is that it's Emily Cowan. And they don't wish for that to be public knowledge, which is why they're not going to have a public court about it, and they're just going to censure her because she couldn't have done it without the judiciary helping her out. And amazingly enough, Emily Cowan's the same one who issued the illegitimate, unlawful show cause order against Alan Smith. And apparently she's the one that, from the stories I've heard from Alan and multiple witnesses, Tamara Lee and Madison Hill, which was Alan's attorney, who he was paying thousands of dollars to, tens of thousands of dollars to, told him and threatened him that if he didn't sign the consent order against his consent, that Emily Cowan was going to sign an order taking away his children forever and have the police come and pick them up that evening. And with everything that's just happened, I would say that probably wasn't too crazy of a threat. That's kind of believable. And Alan and Nika and several other people have written judicial complaints against Emily Cowan for what she has done in Alan's case, and they've just dropped that. They said, we can't do anything about that, even though she's showing extreme prejudice and extreme bias to Tamara Lee. We don't have any action that we can do to protect the public from judicial officers that act bad, because they won't do anything until a bunch of people start complaining and telling them how wrong it is. I am sure that hundreds, if not thousands, if not tens of thousands of bar complaints went in against Greg Newman before the state finally decided, okay, we'll just pick the worst one and we'll make a show of it to try and appease everybody. And then they suspended his license with a stay on the suspension so he can still operate as an attorney up in Buncombe County. And he probably wouldn't have been removed from office if I didn't start making those YouTube videos talking about how insane it is to allow somebody who's an accessory to child rape after the fact to just walk free. And now we're in the same situation again. And we're going to be in the same situation tomorrow and the day after that. The only thing that's going to change is it's going to get worse and worse if people don't start watching the courts. Now, my guess with what's happened, hopefully, if Tamara wishes to do the right thing and Katie wishes to do the right thing, hopefully they drop the 50B against Alan. But even if they don't, I don't have any real issue with what's going to happen on February 10th. But right now, I'm telling everybody, if you wish to see the outcome of this case and what happens in Hendersonville, if you wish to make sure you can hold the judicial officers accountable, if you wish to make sure that you can make sure law gets upheld at your local courthouse for you when they're dragging you in on some made up BS bogus stuff because they allow that to fly, because a man wishes to exercise his right to lawful, peaceful non-compliance, who's already said multiple times, if you just swear under oath or affirmation that the order is true, lawful, and correct, I'll carry it out. Let's see what happens.
No, we didn't, we didn't. All right, we are back on the record after Mr. Cross was removed from the courtroom, at the direction of the court. Mr. Gross?
That's cool. Hold on. I'll say thank you. Hands on, put them aside for a moment, readjust if you like.
That's fine.
Sure, let me, better for you, I'm comfortable standing, I'll see what I can.
You're going to follow the direction of the court and the direction of the sheriff. We can do this one of two ways. I can remove you from the court, I can make all the findings in your absence if you are not going to be compliant with direction. We are also willing to accommodate and have you step and reacclimate to us, so that they are not causing discomfort. So I will give you that choice. Well, because you're not complying with the court's directive.
The moment you swear on the oath, that oath and affirmation that you have a law of order, then go ahead and there you go.
I would come to court on February 17th and watch what they do to Alan and witness it so that you can have a pretty good idea on what you're looking at when they pull your number. Because we are just conspiracy and we just wish to conspire to bring heaven down to earth, and you can either join this conspiracy or pick a number, get in line, and wait for them to do it to you. One world, love, and peace.